Get ready for the legal dictation at the speed of 100 words per minute. Start. The High Court, by the impugned order, dismissed two appeals arising from separate orders of the Motor Accident Claims Tribunal, hereinafter referred to as the Tribunal deciding two accident compensation claims. The appellants had claimed further enhancement of compensation. The deceased in the first appeal was a housewife aged about 30 years. The second deceased was her daughter aged about 12 years. The claimants are the husband/father of the deceased and three minor siblings. The two deceased on 25th December 2012 were traveling in a horse cart along with some others to a religious congregation. The horse cart was hit by a bus, resulting in their death. The tribunal assessed the notional income of the first deceased at Rs 36,000 per annum, and after 1/4 deduction towards personal expenses with a multiplier of 17 awarded a compensation of Rs 4,59,000. The tribunal then deducted 50% on ground of contributory negligence, as the horse cart was stated to have been in the middle of the road when the accident took place. A sum of Rs 1 lakh was then added as a loss of consortium and Rs 25,000 towards funeral expenses, leading to an award total of Rs 3,54,500 with interest at the rate of 7.5%. Insofar as the minor child is concerned, the notional income was assessed at Rs 36,000 per annum, applying a 50% deduction towards personal expenses with a multiplier of 15. The compensation was awarded at Rs 2,70,000, out of which 50% was again deducted towards contributory negligence. A sum of Rs 25,000 was added towards funeral expenses, leading to an award total of Rs 1,60,000 with interest at the rate of 7.5%. The appeal for enhancement of compensation was dismissed by the High Court, and thus the present appeals. Learned counsel for the appeal submits that the notional income of the first deceased has been wrongly fixed, ignoring her income of Rs 5,000 per month from dairy farm business. Nothing has been awarded towards future prospects. With regard to the second deceased, it was submitted that she was studying in a school and her notional income should have been assessed at Rs 54,000 per year. Nothing has been awarded towards loss of estate, loss of consortium, and funeral expenses. The common submission in both the appeals was that deduction on ground of contributory negligence was unsustainable and unjustified. Reliance was placed on Kajal versus Jagdish Chand and others 2020 SC 776 to contend that the income of the deceased child should have been assessed at Rs 4,846 per month. Learned counsel for the respondents submitted that the present appeals do not merit interference. There is no evidence with regard to the claimed business income of the first deceased. The finding of contributory negligence merits no interference. In absence of any proof of income, the question of future prospects simply does not arise. Similarly, the second deceased was a minor school-going child who also had no income, and therefore the question of grant for future prospects with regard to her also does not arise. We have considered the submission on behalf of the parties. No evidence has been led by the appellant with regard to any income of the first deceased from dairy business. The deceased were traveling in a horse cart along with others to a religious congregation. It is not the case of the respondents that the first deceased was driving the horse cart or was the owner of the same, much less that it was being driven under her supervision.